Well, the question really shouldn't be, should I avoid probate at all costs? But should I avoid probate because there's no benefit to it and there's a better way? What's the better way? California, the better way is a revocable living trust. Just make sure that it's working as it should. Washington, we have different considerations here as to whether probate should be avoided or if probate might be great, might be a really good thing. I'll get to that. Oftentimes when we meet with clients, we suggest that they avoid probate, but we don't do it through a revocable living trust because that's more complicated than it needs to be. Yes, we will have a will and say, here's the will that backs up what you want. But let's say you're a single person, you've got 2 kids and you want the kids to inherit equally. That's a pretty simple estate plan, right? So how would we set up their estate plan? We'd have their will that says that, but we are going to avoid probate. How are we going to do that? Your bank accounts can pay on death to your beneficiaries. So if you have 2 kids, pay on death equally to the 2 kids. Life insurance, same thing. IRA, 401k, same thing. Your beneficiary designation will say, pay to my children in separate but equal accounts. Your retirement funds will pay out. All they need to do is give your death certificate and all of this will happen. Your car, same thing, an affidavit of inheritance. That's all you need. So where might this avoid probate not work? If you have a house. If you have a house, your house will go through probate unless you've done one very important thing, and that's what's called a transfer on death deed. This is something that we can do in Washington. We can't do it in Idaho, but in Washington, we have a deed. It's called a transfer on death deed. You need to sign it during your lifetime, and it can say it goes to 1 beneficiary or 2 beneficiaries. Frankly, when it gets beyond that number, we don't like to do a transfer on death deed, because when you do a transfer on death deed, let's say it goes to your 2 kids. Well, they're going to both be joint owners. So they both have the say-so about what's going to happen with that house. So with a transfer on death deed, the recipients should get along with each other. That's the goal. Even though your will said it's going to go to my 2 kids, your will isn't probated, it doesn't get filed with the court because the transfer on death deed instead directs that asset. So if probate has no benefit, avoid it. But let's say probate has a benefit. This is where I need you to listen to, and it's because it's going to be counterintuitive to you. You're going to say, probate has a benefit? Lynn, I have never heard that. Probate has a benefit. Here's how probate has a benefit. Are you in the state of Washington? Do you want to protect assets for your spouse if you're the first to die? Does your spouse possibly have long-term care in their future? Do they have a diagnosis of Parkinson's or Alzheimer's? Or even if they don't, statistically, somebody who is over a certain age, 65 or 70, the likelihood is, the probability is they will need long-term care. For how short or how long, that's a different question. But they will need long-term care, probability-wise. So in the state of Washington, the only way one spouse can protect assets against long-term costs from another spouse, for the benefit of another spouse, is if they do it through a will. The will has to contain this special kind of trust. It's either called a supplemental needs trust or an asset protection trust. What it is, it's what we call a discretionary trust. That trust has to be in the will. And in the will, with this trust, upon the death of the first spouse, then all assets will go through the will into this trust. You heard me say they'll go through the will into this trust. How did that happen? That happened through a probate. The only way to protect assets for your surviving spouse in Washington against long-term care costs when you're gone is through the probate process. So does that make sense? Let's say the couple, Fred and Sally, had $1 million estate. their house is worth $500,000 and they have $500,000 in investment and bank accounts. Fred dies first. Sally is the survivor. Fred's half of the estate is $500,000. We can put that $500,000. Sally has Alzheimer's. Sally needs long-term care costs. Sally will not qualify for Medicaid or the state to pay for her care unless that Fred's will has this trust for her. So by having a will with the asset protection trust, we can protect $500,000 for Sally. Sally's the surviving spouse. She has Alzheimer's. She owns the house in her name, and she has $500,000 in this trust that her husband's will created for her. Sally qualifies for Medicaid, for the state to pay for her care, even though she has $500,000 in trust. If you know anything about Medicaid, Medicaid says a single person can only have $2,000 to their name plus a house. Sally's $500,000 isn't considered hers because it's in a trust. So Medicaid doesn't count that $500,000, and the house also is not counted. It's an exempt resource. So through this really powerful estate planning tool, a will with an asset protection trust, you can make sure your spouse will never, ever become impoverished. They will always have that money in trust because that money never has to be spent on long-term care costs. It can be if you want it to pay for a private pay period, for example, but it doesn't have to be spent. Medicaid instead will cover the care costs. And that is a really important estate planning concept that I want to make sure that I share with you. The only way to get that result is if we do a probate. So if I say to you, probate can be a good thing, that's what I mean. Probate is a way to protect assets for your surviving spouse. And the only way we can do it in Washington is a will that goes through probate. So that was myth number 3. Probate is bad and should always be avoided. Oh, one more thing before I go on. I was talking about a surviving spouse having assets protected. It's for any beneficiary. It's not just for your spouse. Let's say that you've got 3 kids and one of them has lifestyle issues, or one of them is facing a divorce, or any myriad of situations you can think of where the person inheriting from you might need asset protection. It can go into this kind of a trust. Let's say that one of your children is disabled or some special needs. Your will can provide for them in the same kind of trust. Any assets they inherit into this type of trust are not considered by the government to be owned by that person, so their benefits can continue uninterrupted. The money in this trust does not interfere. So it's a great way. Probate can be a very good way to protect assets for those who will inherit from you. Make sure that those assets do good for them, that their state benefits are not interrupted because the money isn't considered theirs. So what I want to leave you with is that probate can be a really good thing in the right situation.